Hi, everyone. Let's get started. Welcome to what I call my Magic 8-Ball session, which you'll know if you've been following this series is the opportunity for me to answer some of your specific questions that arise out of some of the issues that have been raised in previous sessions or something new. It may be a problem in your file. It may be something you just have always wondered about. So I've got about 5 questions that I am going to address today. So let's look at those 5 questions on the PowerPoint. But before I start, this is the 8th of my series. Thanks for those of you who have sent questions to me or comments. And just a reminder to send those questions to me directly to my email and not in response to the invitation to the events, because they come to me more quickly if you send them directly to me. So as usual, I'll have you out at 1 o'clock today. So let's look at the 5 questions that I've been asked. So the first question is actually the hardest question. So I'm going to deal with it first. And the question I got is a little more detailed than the one I've got up on the screen. So let me tell you the full question. Can a respondent obtain a summary dismissal or some kind of default proceedings in an arbitration where the arbitration agreement does not provide a process for the appointment of the arbitrator, and the claimant has served a notice to arbitrate but has taken no steps to appoint the arbitrator? So I'm going to start with an analysis of Ontario law because there are some other provinces that have similar legislation, and then at the end of this I'm going to comment on some of the issues that arise in some of the other provinces. So let's start with what happens in this situation when the claimant doesn't pursue the arbitration when the tribunal has already been appointed. And there is provision in the Ontario Act and in the model law for a dismissal of the proceedings where the claimant refuses to act. So section 27 sub 1 of the Ontario Act, for example, says that a tribunal may, 25 says that a tribunal may require the parties to submit their statements within a specified period of time. And section 27 sub 1 says that if the claimant has not submitted a statement within the period of time specified under section 25 sub 1, the tribunal may, unless that party provides us an explanation, make an award dismissing the claim. And likewise, section 43 says that the arbitration is terminated when there is a final award, or the tribunal terminates the arbitration under section 27, or if a claimant withdraws a claim. So, and there's a similar provision in the model law called default of party. Article 25 sub A, unless otherwise agreed to by the parties, the claimant fails to communicate his statement of claim in accordance with Article 23, the tribunal shall terminate the proceedings. So the difference in the model law and the Ontario Act is the tribunal shall terminate the proceedings under the model law and may do so in the Ontario Act. And the Ontario Act provides that the claimant may provide a reasonable explanation. Article 32 of the model law says the tribunal may terminate proceedings where the tribunal finds that continuation of the proceedings has become unnecessary or impossible. And that sounds like a very high threshold to meet. So those sections say that there is a way that a respondent can, after the tribunal has been appointed, ensure that the claimant proceeds with the arbitration in a timely way. But what happens, as in the scenario of the question that I was asked, where the arbitration has been formally commenced by the notice of arbitration, but no tribunal has been appointed? The bottom line is, because of the principle of competence, the courts have very little jurisdiction to interfere. And so that in this situation, the respondent is in a little bit of no man's land. Section 6 of the Arbitration Act specifically provides that the court has very limited powers to intervene and to assist in the conduct of the arbitration. So assist certainly doesn't sound like terminate. So under the principle of competence, if there's a challenge to the arbitrability or jurisdiction, and it's arguable that the dispute falls within the jurisdiction of the tribunal, then a court has no jurisdiction and the matter has to be determined by the tribunal. And of course, here there is no tribunal. Under Section 28, the court may declare an arbitration invalid. So a court proceeding can be brought in order to find the arbitration invalid in specific circumstances where the arbitration agreement is invalid or has ceased to exist, where the arbitration agreement does not apply to the dispute. This is a scope argument, and it must be very clear that the scope of the arbitration clause doesn't include this agreement, this dispute, because otherwise that matter goes to the arbitrator. Under the model law, the ability of a court to intervene is arguably more restrictive because Article 5 says that no court shall intervene except where so provided in this law. So the court really has no jurisdiction to act in this scenario. So what does it mean? There are a number of options. The best option is for the respondent to actually move for the appointment of an arbitrator before the course and likely seek costs. So long as the validity of the arbitration agreement is not at issue, the courts will hold the parties to their bargain that they intended the dispute to be resolved within the arbitration. So the courts will hold the parties to the arbitration agreement, which is why the best outcome for the respondent is to move for the appointment of an arbitrator, and the arbitrator will deal with the delay issues in the circumstances that I've described earlier about what a court can do. The respondent can then seek a deadline for the exchange of statements, could argue perhaps that there's been a waiver of the right to arbitrate, but this of course would have to be a clear waiver on the evidence, very difficult to show. If the claimant fails to follow procedural orders, this will likely have to be decided on the merits ultimately anyway. This is not unlike court proceedings where procedural issues are not usually the reason that the matter gets dismissed. So the question is whether, for example, a summary judgment motion could be brought. That was part of the question. And one of the corollaries of that is a summary judgment motion really the best process when arbitration can often be a lot faster than court proceedings in any event, but obviously that's a strategic decision. The party to the respondent to the arbitration may then decide that dealing with the issue on the merits quite quickly is the best approach. So can bring a motion for summary judgment unless the arbitration agreement provides that a motion for summary judgment is not allowed. Courts or arbitrators will generally hear such a motion. But there may be, for example, an argument that the limitation period has expired. That may also be an explanation for the claimant having brought the arbitration, formally commenced it, but done nothing to advance it. There may be a limitation period issue, and that may be something the respondent wants to deal with early on. And the arbitrations usually are much more likely to bifurcate proceedings than court proceedings are. So for example, the respondent may be able to get the limitation period issue determined early on. Now, often limitation period arguments require an analysis of the background and the substance, but if this is a very clear limitation period argument, the arbitrator may agree to hear that separate and apart from the other defenses and liability issues. So that, in my view, is the best option. An alternative is if the respondent has a counterclaim, that counterclaim can be advanced in court. If the claimant in the arbitration raises no objection, then the court will hear that counterclaim, and it may be that that counterclaim then is the claim, and the claimant's claim in the arbitration becomes the counterclaim. If the claimant is determined that the matters in dispute are to be decided in the arbitration, then the defendant in the action may seek an order staying the action in favor of arbitration, and we've talked about stays in previous sessions. But of course, that kind of strategy risks an adverse cost award against the respondent in the arbitration. So query whether that's the best outcome, particularly if the arbitration is absolutely clear that the parties wanted to arbitrate. However, to add to the level of complexity, one of the grounds for denial of a stay of proceedings in favor of arbitration is that the matter is appropriate for default or summary judgment. And under the Ontario Act, that is found in section 7 sub 2 5. So if a matter is likely to or appears to be appropriate for default or summary judgment, the court may decline the stay of proceedings in favor of arbitration. And the case law on whether that is appropriate is not entirely clear, but there are cases that show that the court may determine that the case is an appropriate one for summary judgment and not require that a summary judgment motion be made as part of the determination of the stay issue. And an example of that is the Gensel case. And again, I will give you all of the cases and links that I refer to in this session following this session. But it's called Gensel 407 Yonge Street against Bright Immigration 2021 ONSC 6030. And that's an example of a case in which the court decided that the stay would not be granted because the matter was appropriate for summary judgment and there was no summary judgment motion before the court. So that's another alternative under this scenario. A third alternative is there evidence that both parties have abandoned arbitration and so the matter is properly before the courts? So if the respondent to the arbitration, for example, sues in the courts and the other side does not contest the matters proceeding before the courts, that may be sufficient evidence that a court will accept that the parties have both abandoned their rights or intentions to arbitrate. But if the other party does contest, we're obviously into a stay motion. So what kind of evidence is required in order to show that both parties have abandoned the arbitration agreement? Silence is not evidence of abandonment. So simply because the claimant has done nothing to pursue the arbitration is not sufficient evidence of abandonment. Most arbitration agreements don't contain time limits for the delivery of material, for the appointment of arbitrators, etc. So it's really difficult to show that the claimant is moving too slowly and has waived its rights. Can it be argued that there's an implied term that the arbitration must be commenced and pursued within a reasonable time? There must be some kind of evidence of this reasonable period of time and that the parties reasonably intended it. The prejudice to the respondent may not even be sufficient unless the respondent was reasonable to believe that the parties intended that there be some timelines in the arbitration agreement for the process of the arbitration, and the claimant intended to abandon the arbitration if those timelines were not met. Very unique scenario, very unlikely that that will occur in many cases. Then, of course, you see some outliers in cases, which is always possible. And there's a case called 1100 Walker's Line against Elliott Sports Medicine Clinic, 2021, Ontario Supreme Court 5067, in which the court said that a party can sue when it's obvious that the other party will not participate in arbitration. And in that case, the court made that determination simply because the other party did not object to the court proceeding. So the final option, which I think is the least ideal option, is that the respondent simply sit on its hands and do nothing and wait for the claimant to proceed with the arbitration. There is no requirement in arbitration law that if the claimant delays for a certain period of time, the case will automatically be dismissed or administratively dismissed within a certain period of time. That doesn't happen. And part of it, again, is that the the arbitration has been commenced, but there's nobody who has carriage of it because the arbitrator hasn't been appointed. So if the respondent chooses to do nothing, the arbitration may go away, but it may not. And if there's some concern that the respondent has that evidence will not be available if there's much of a delay, for example, there's a crucial witness who is elderly or has an illness that suggests that witness may not be available in the long term, it really is important for the respondent to weigh all those factors, the possible prejudice, and determine whether sitting on its hands really is a good approach. So the interesting thing is that this problem, which appears in Ontario and the legislation in some of the other provinces, is in some sense avoided. Under the BC Act, there is a general duty of parties to do all things necessary for the just, speedy, and economical determination of the proceedings in accordance with the agreement of the parties. And a party must not willfully do or cause something to be done to create the delay. Similar provision in Article 2 of the Quebec Civil Code, which requires parties to fully participate in the process in good faith and to cooperate in searching for a solution. It requires parties to jointly proceed with the arbitration. And so this may give rise to a right on the part of the respondent to seek a court injunction preventing the arbitration from proceeding because the claimant hasn't proceeded in accordance with its duty to do so, or that it may be a better idea to get the arbitrator appointed and ask for that relief from the arbitrator. So there are strategic reasons why one approach or the other might be better. The overall answer to this question, though, will be found in the law of the seat of the arbitration. So I've talked about some of the provincial legislation, but if the seat of your arbitration is elsewhere, you really do have to do the analysis to see whether there is something that can assist in dealing with this if the respondent is left hanging. So that's my first question. Question 2, are there risks to a respondent who in an international arbitration with a foreign seat who refuses to participate in the arbitration? And the answer to that question is yes, and I'm assuming everybody knows that. I've got 2 examples of that, one a domestic case and one an international case. And I think the real important lesson to be learned in this case, first of all, is respondents can face problems and prejudice if they don't participate. And secondly, if you are counsel and you are asked this question, do not tell your client that they shouldn't participate. And this is what happened in both of these cases. So the domestic case is Van Hoff, VANHOF, against Van Hoff and Blocker Acquisition, 2021 ONSC 7211. The situation involved an alleged breach of the asset purchase agreement, and the purchaser commenced the arbitration. The sellers refused to participate in the arbitration, but ultimately appealed the final award. The appeal was dismissed. Under Section 27 sub 3 of the Ontario Arbitration Act, if a party fails to appear at a hearing or produce documentary evidence, the party may, unless the party offers a satisfactory explanation, continue the arbitration unless the party offers a satisfactory explanation. So here, the sellers refused to sign the terms of appointment of the arbitrator, but filed material and were notified of the hearing dates. They failed to show. They appealed on the basis that the arbitrator lacked jurisdiction. And the sellers believed that the arbitration could not proceed unless they signed the terms of appointment, which turned out not to be true, according to the court. And because the sellers failed to raise the jurisdiction issue at the arbitration and also failed to respond to the substantive claims, they were stuck. And the court noted that they were represented by counsel who presumably had given this advice to them, which gives rise to a question about whether there was a following negligence claim. but the appeal was dismissed and the award stood. The next example is an international one. UMS Solutions against Cornell, 2023, BC Supreme Court 214. This was an unsuccessful motion to dismiss a BC action to enforce a New York judgment, which was obtained because the BC resident defendant or respondent in the arbitration proceeding failed to participate in a New York seated arbitration. So the plaintiff was successful. The plaintiff in the BC action was also the claimant in the New York arbitration under the AAA rules, obtained an award. The claimant then got a New York judgment confirming the award. And the defendant was unsuccessful in getting that award set aside that order set aside in New York. Following that, the plaintiff then sued in BC to enforce the New York judgment. And the defendant, and this is the decision here, the defendant argued that the plaintiff had inordinately delayed pursuing the action in BC, and so therefore the claim should be dismissed. The BC resident defendant was unsuccessful. A little bit of history is important to understand the full extent of the opportunities that this defendant had to participate in the arbitration and in the New York proceedings. So in 2016, the defendant advised the AAA directly that the claims had no merit and that he was not able to travel to New York, which was where the arbitration was taking place, because of family illness. In 2017, so a year later, the defendant received notice of the hearing dates, but did not attend, and ultimately the defendant received a copy of the award made against him. In 2017-2018, the plaintiff brought a petition in New York to confirm the award, and the defendant received notice of that but failed to respond. A side issue here is why the plaintiff didn't simply rely on the New York Convention and get the award enforced in BC. And there's no answer to that question in the decision. The claimant simply got the award confirmed in New York and then tried to enforce the New York judgment in BC. In 2018, the New York court gave the defendant another opportunity to respond and said, now is the time to provide us with your substantive defenses if you have any. The award was confirmed the following year and the appeal period expired. So far we've got a 3-year period from the first notice that the defendant respondent has to the arbitration to the point in time where the award gets confirmed by the New York court and the appeal period expires. The action is then brought in BC, and the defendant moves to set aside the New York judgment, and so goes to New York and moves to set aside the New York judgment, and his evidence in New York on the motion to confirm the New York judgment is that he received advice from a Canadian lawyer that he need not attend in New York because enforcement of the award against him in BC would be difficult, and that in Canada he would have an opportunity to challenge the enforcement of the award. And he said he had a good defense, but he didn't want to spend money in New York and travel to New York to face meritless proceedings when he knew he'd have an opportunity to do so in BC. So the plaintiff then sued in BC to enforce the New York judgment, and the defendant refused to participate in the BC action for a year and a half, then moved for dismissal of the BC action for delay, arguing that this circuitous route that the claimant had taken by getting the New York judgment, New York award confirmed in a New York judgment, and then the motion to have it enforced in BC. And there were bad reasons that the defendant alleged for this circuitous route. The motion was dismissed, and the court found that any prejudice that this BC resident had incurred were as a result of his own behavior. And I say that the end result of this would have been the same under the New York Convention because of the limitations in having in preventing the enforcement of an award. But that's quite an extreme example of a party not participating at all in a process. But what it shows is that it's important to participate in the foreign proceeding, particularly given all of the chances that this person received. It's very difficult to argue prejudice or lack of notice. And the lawyer advising should really, like all cases, understand the issues before giving advice. The next issue, the third question, is should the arbitrator record a hearing if the parties don't want a transcript? And I've had this question a couple of times. So from the arbitrator's perspective, you can see that there are some real potential benefits to having a recording of the proceedings, even if there is no transcript. The arbitrator places less reliance on their notes, allows them to pay more attention to the hearing, the evidence, and possibly ask questions. It also allows the arbitrator to review the recording later when drafting the award to make sure that the evidence and argument as set out in the award are absolutely accurate. It's a good reminder for the arbitrator on the impressions they had about the various witnesses, and it may be particularly helpful for a long hearing. That the idea of having a recording also provides for some relief for the arbitrator, who will have less work at the end of the day trying to summarize what occurred during that hearing date. So those are the pros. The cons include why the arbitrator would take responsibility for recording a hearing when there's a risk that if there's a failure with the recording, that the arbitrator will have taken responsibility, and then will there have to be a redoing of the evidence? I don't think the arbitrator wants to have that responsibility. So if the idea is that there's a recording made, the parties should take the responsibility for that. Another big question is if the parties don't want a transcript, does the fact that there's a recording raise the possibility or increase the likelihood that there will be a challenge to the award, either a set aside or an appeal? The fact that one of the parties who wants to challenge the award has no actual evidence of what took place during the hearing may be a deterrent to that party in bringing a challenge. And not sure that's really that thinking should factor into whether the arbitrator wants to make that decision about a recording. This really should come from the parties. But even if there is no recording and no transcript, there are ingenious counsel who figure out ways to challenge an award. And one of the examples of that is 1150 Alberni Limited Partnership against Northwest Community Enterprise, 2021, BC Supreme Court 2053. And this was both an appeal and a set aside on the basis of a denial of natural justice in circumstances where the parties agreed to a baseball arbitration. And so they clearly chose that for speedy resolution and perhaps some cost savings, because transcripts can be quite costly. And the terms of the baseball arbitration were that the arbitrator had to choose one party's proposal in its entirety and provide reasons. And this puts the arbitrator in a very difficult situation. So consider whether you would even agree to these terms. Because what if, for example, the evidence in the arbitration doesn't neatly fit with either proposal, and yet the arbitrator is required to deliver reasons? Well, the appeal and the set aside were denied, not surprisingly, but you can see that even in a situation where the parties are trying to cut corners or reduce the amount of process in their arbitration, there really is still a risk. From the parties' perspective, why would they want no transcript? Costs is a huge issue. there are significant costs associated with particular simultaneous or daily transcripts. And speed may be an issue. If parties don't want the transcripts immediately and have to wait for them, is that going to affect the speediness of the arbitration? So then we get to the issue of costs. Are they or not they prepared to pay for the speedy justice that they want? Cons. Cost savings may be short-sighted. There's no doubt that if you have no record, it is much more difficult to challenge the award later. Disagreements about what the evidence may be, memory problems, must be common. Even with a short hearing, every participant in the arbitration will probably come away with a slightly different view of what happened during the arbitration. So there really are, apart from cost savings, no reason why the parties shouldn't want to have some kind of a recording or transcript. So then my next question is, what is the standard required of an arbitrator to deliver a reasoned award? When can reasons be considered insufficient to justify an appeal or a set-aside proceeding? And you see in a lot of cases recently, a whole basket of challenges to the award, and often the insufficiency of the reasons, it falls into the group. So what is a reasoned award, and what are sufficient reasons as opposed to insufficient reasons? So we know there are legislative requirements. Under the Ontario Act, Section 38, the award shall state the reasons upon which it is based, of course, unless the parties agree otherwise. Similar provisions apply in some of the other provinces. The BC Arbitration Act says that the tribunal must provide reasons for an award unless the parties have agreed that no reasons are to be provided or the award is on terms agreed. So if there's a settlement, for example, the award doesn't need to contain reasons. There may also be the institutional rules that the parties are using, which provides a reason requirement. For example, the ICC, VANIAC, ADRIC rules, reasons are required. Now, interestingly enough, this is not the common practice in the US. So for example, the AAA discourages reasoned awards. And although there's a precedent for them, they are surprisingly short. So even a reasoned award commonly found in a US domestic arbitration, the reasons are not, I would argue, sufficient to meet the test in Canada. As I've just said, whether the parties receive a reasoned award is something that they can contract out of. But the question is whether there's wisdom in that, if there's a chance that the parties will want to appeal or set aside an order or an award. So what is required to deliver a reasoned award? Generally, the case law says that the reasons in awards need not be as detailed as the reasons of a court. Why? There's no value in the reasons of an award in the same as a precedent, which is one of the objectives of court reasons for decision. So there's a public versus private purpose rationale. Often the speed and efficiency public policy purpose is given as a reason. The parties are expecting speed and efficiency in getting their arbitration proceedings resolved, which may inform the concept that the reasons in an arbitral award need not be as detailed as in a court proceeding. And the consequences of a less reasoned award are often that a court, unless there's something grievous that's been done, will not interfere. And another rationale is that there may be confidentiality reasons why the parties would like less detailed reasons and why the arbitrator offers them, so that there is an appeal or there is a set aside, there is less confidential information disclosed in the public arena. But the reality is that even though there are principles that I'm going to tell you about, the scope of the duty to deliver a reasoned award on the part of the arbitrator is not that clear. And there's a great article on this topic which I'll send to you, but it's in the Canadian Journal of Commercial Arbitration, and it's called the Reasoning in International Arbitration, the Emergent Approach in Canada. And I would argue that that same approach applies to domestic arbitration awards. There are a couple of cases that talk about this standard. Shaturagi against Divanagi, and I'm not even going to try to spell that because I'm going to send you the citation, 2021, BC Supreme Court, 1576. It says that the standard of a reasoned award, in this case, in a statutory arbitration, need not meet the standards of a judge. And then the Lululemon case, 2021, BC Supreme Court, 15, the parties' expectations as to the completeness of an arbitrator's reasons are less than before a judge. This gives rise to a number of questions. Does a reasoned award make it more likely that the answer will be right because the arbitrator has thought about it more and gone through a detailed analysis? Does a reasoned award make it more likely that there will be a court challenge because the reasons provide a foundation or for a challenge? Or does it make it less likely because the parties fully understand why the dispute was decided as it was? Is there a different standard that applies if, for example, the arbitration agreement provides that there is no appeal whatsoever? And is the procedural history more important because of the possibility of a set aside? So the court principles in deciding what the difference between an arbitral award and a court reasons for decision can be described as purposive. So the award must do the following. It must let the parties understand why the result was obtained. How and why did the arbitrator come to the decision? It need not address every argument the parties have made. It must demonstrate that the arbitrator understood the parties' arguments and what evidence was accepted and why. The sufficiency of reasons may depend upon, again, whether there may be appeal, and if so, on what grounds. A good summary of these principles is Wang against Takar, 2019, Ontario Supreme Court, 5535. It gives a good summary on what makes an award sufficient. And essentially, the court says the arbitral award must show the why, even if it doesn't show the how. In other words, it needs to show the logical connection between the evidence, the law, and the decision. And if that reasoning is deficient, the matter may be remitted back to the arbitrator. Another case is Charlottetown against Charlottetown Airport, 2020 PESC 41. This is a discussion about the law relating to sufficiency of reasons for the award. The award should have facts, the law, the application of the facts to the law. One of the purposes is to provide informed grounds for consideration of grounds for appeal. And another important case, Peralta against Peralta, 2019, Ontario Supreme Court, 2853. The length or brevity of reasons does not equate to sufficiency or insufficiency. So, are you confused? Because I am. I don't think that these are all that helpful guidelines to allow arbitrators to determine how detailed their awards need to be and for parties to have some idea about what is considered an insufficient award. What the case law says is an insufficient award is generally one in which the court cannot understand how the arbitrator came to the decision that they reached. Another question that arises, there is provision in the legislation and the model law, including, that provides that there are 30 days within which a party may raise an issue with the tribunal to clarify or correct the award. And ordinarily, though that provision is used where there's, for example, an arithmetical error in the award, or there's something which has been completely left out and there's going to be injustice. And so the party is providing the panel with an opportunity to correct that. The question is whether the parties should be required to seek that relief from the tribunal before challenging the sufficiency of reasons. And the answer to that is no, in part because of the limited availability of this remedy before a party can challenge an award. And it doesn't give rise to a waiver of a party's right to appeal if there is an opportunity to go back to the tribunal for clarification or correction, and the party doesn't take advantage of that right. So far, the case law doesn't seem to suggest that that is a requirement, but I think that issue remains an open one. So if you act for a party which wants to challenge reasons on the basis that they're not sufficient, that alone is not grounds to have the award appealed or set aside. And there must actually be an argument that this issue gives rise to a ground of appeal or a ground of set aside. So Wang against Takar, which is a case I referred to earlier, says that inadequate reasons may be an error of law which gives rise to a right of appeal. The argument in that case was that the flaws in the reasons prevented a meaningful review by the court of the reasons, and that was an error of law. The other way to characterize the challenge is as a set aside. So for example, in Alberta Cricket Association against Alberta Cricket Council, 2021, Ontario Supreme Court 8451, the award was set aside on the basis that the tribunal had breached its obligation under the legislation to provide reasons. In Marchetta against Lane, 2021 BC Supreme Court 1259, this was a set-aside case in which the arbitrator had provided multiple awards, and it turned out that the facts that were assumed in one of the earlier awards turned out not to be true in one of the later awards. And so the court set aside that award on the basis that there was an error of jurisdiction. And it may be that instead of setting aside or granting an appeal, the court will remit the issue back to the arbitrator for consideration. So one of the reasons this is so important is because there is a trend that there are a greater number of set-asides and appeals going to the courts. And you can just look at the case law and you can see that happening. So the question is, why is that? One of the reasons could be that there is simply more arbitration happening. And that means necessarily that there are more challenges, appeals, or set-asides. Another could be that there is a lot more commercial arbitration happening and being done by counsel whose main practice is commercial litigation. And so they haven't bought into the idea, which is very common in international arbitration and with International Arbitration Council, that there is finality in an arbitration award, and there is very little recourse to the courts to have that reviewed by a court. So maybe counsel and parties haven't really accepted that the intention is that the tribunal is the last stop. Maybe there's an idea that the arbitrator isn't as good as a court. So it's not clear, obviously, which of those answers is the correct one, and maybe there's a combination of all of them. But what has resulted is that this whole issue of the sufficiency of reasons gets kind of lost in the reality of the fact that arbitrators are providing much more detailed reasons. And I would argue that they're in many cases akin to what you would expect from courts. So in a sense, this is somewhat of an abstract problem. But the interesting thing is that challenges arise even where the parties request abbreviated reasons. So arbitrators can't catch a break even when the parties request it. And I'm going to give in the material that I sent to you a couple of cases in which that occurred. One of them is called Nolan and Ramirez, and the other is called Alvarez and Alvarez. And there the parties specifically requested shorter reasons. So we're almost out of time. So I'm going to deal with my last question, which is, what's the big deal about the Aroma case that the people are talking about? And this case is the Aroma Franchise Company, Inc. against Aroma Espresso Bar Canada, Inc. 2023, Ontario Superior Court, 1827. And this case is under discussion right now because it raises a new issue that we haven't seen in the case law before, and that is in circumstances in which the arbitrator had engagements on behalf of one of the counsel to an arbitration, the Aroma arbitration. The court found that this gave rise to a reasonable apprehension of bias. There was an obligation to disclose this, and the two awards were set aside. And the reason, and the way I've described that, it sounds like a fairly simple issue, but in fact, the circumstances are quite complicated, and I would argue that a reasonable person in the seat of the judge who decided this issue could have made a finding going the other way, and that there was no reasonable apprehension of bias. So let me try to tell you a little bit about this case, and if you want to know more about it, because I'm obviously going to try to whip through this. My blog, Arbitration Matters, I put out an analysis of this case on Monday on the website, www.arbitrationmatters.com, and I've given you my thoughts about this. But let me give you an overview of what I think are the important principles here. First of all, there was a discussion by the judge about generally what constitutes a reasonable apprehension of bias. And it's clear from this court decision, and I think from other court decisions, that this Ontario domestic test is no different from the international test in Ontario and the domestic test in places like the BC Domestic Act. Justifiable doubts as to the arbitrator's independence or impartiality. This case supports the view that I think is gaining steam, that those two tests are essentially the same. And so as a result of that, the court looked at the IBA guidelines on conflicts of interest in international law, which I did in an arbitration boot camp early on, session 3, ethical issues part 2, and I went into those details quite thoroughly. And this is one of a very few cases, domestic cases, that have applied the IBA guidelines. And so this issue is starting to gain acceptance, that the IBA guidelines are useful in domestic arbitrations to deal with this issue. The other factor that I think is important in this case is that the IBA guidelines don't really address this particular situation in any clear way, and arguably the IBA guidelines are inherently inconsistent on how an issue of this kind could be decided. And the last major issue is that the court considered a UK case, which is considered to be right now the leading case on multiple appointments, and it's called Halliburton Company against Chubb Bermuda Insurance, 2020, UK Supreme Court 48. And this was a circumstance in which the arbitrator was appointed by the same party on multiple occasions where there were overlapping issues arising out of the same incident. And you can see that Chubb is the insurer defendant. And so these were, insurance claims. And notwithstanding that this arbitrator was engaged in multiple appointments for the same party without disclosing them, and the issues were overlapping, the UK Supreme Court said there was no reasonable apprehension of bias, and in these circumstances, a reasonable person would not have determined that there was a reasonable apprehension of bias. So the issue, as I've said in my previous ethics session, is there may be a duty to disclose, but that does not necessarily mean that there's a reasonable apprehension of bias, and that's what the UK court found. And the idea that in those circumstances, which are very different from the Aroma case, in which the arbitrator had only one other appointment and the issues were actually not overlapping. There were different parties and a different agreement and different issues. And so the Halliburton case is one that an arbitrator could reasonably look to for guidance on whether there was a duty to disclose or a reasonable apprehension of bias. And so that's why a reading of this case, I think, is really useful when you're challenging an arbitrator on a potential bias issue, and as an arbitrator, whether you are creating, whether you have a duty to disclose. And I would argue that the obligation to disclose is becoming much more broad all the time, and there is greater risk to arbitrators who don't disclose circumstances which previously may not have been something that was well accepted to require disclosure. And this is a particular issue if you're arbitrating in a place where it has lots of arbitration in a fairly small place like Toronto, like Vancouver, where the parties know each other on a regular basis, and you see other parties, or you see other counsel and arbitrators regularly at law events, and those kinds of circumstances may now or increasingly become ones that need to be disclosed. So it's becoming increasingly risky for arbitrators when they're making disclosure decisions, and they make decisions not to disclose. So that's my answer to these 5 questions, and I don't see any questions in the Q&A box, although I'll wait a few minutes before I sign off. So if anybody's got a question, they can ask it. And I don't see anything in the chat box. So let me tell you about what I'm doing next time. So I cited a lot of cases in this session, and I will send to you a list of all of those resources, how to find them. My next session is June the 15th from 12 to 1 p.m. and it's on advocacy in arbitration. In other words, how do you compare and contrast advocacy in arbitration versus regular litigation? It's going to be my last session in June for the summer. I'll resume in September for my last of the 10 episode series that I had planned. And I have a topic in mind. But if anybody's got something they'd like to hear about that they think could take a whole session, I'd be glad to hear it. My topic right now is 10 things people get wrong in arbitration, and it's a focus on counsel mostly, but sometimes judges. So if you think that's useful, let me know. If you'd like to hear something about somebody else, I'm open to it. Reach out to me. I love to hear your feedback, and I love to hear your comments on the sessions or what you'd like to see. Or I've had lots of people reach out to me with additional information about cases I didn't know about and that sort of thing, or things happening in other jurisdictions that I didn't know about. So feel free to reach out to me. Have a great day.